Thank you very much, Carolyn, and to Kaylee for that. I am, before I begin, just going to acknowledge that I was very privileged to be able to conduct my doctoral research on the traditional lands of the Ngunnawal and Ngambri peoples, paying my respects to their elders past, present and emerging, noting that the land has been taken without treaty consent or compensation. So, Hayley, thank you so much for doing the setup of really laying out what coercive control is and your mentions of financial abuse, which can take on a wide variety of forms. My doctoral research focused on financial abuse and specifically scenarios where the victim of domestic violence is entering into contracts in the context of an abusive relationship. This form of financial abuse can leave victims with huge financial liabilities, and financial instability and insecurity is one of the key reasons why women may remain in abusive relationships and not be able to extricate themselves from those relationships. That devastation, that financial devastation, is something that cuts across class. So in the research that I did, the cases that I looked at involved some victims who had substantial assets, but those assets were threatened by mortgages that they might have been forced into signing. But my study also included very poor women who would have been deprived of fair outcomes in property settlements because they were forced to sign unfair prenup agreements. So the key thing about my research, and the reason why I was so interested in these contracts that can be signed in abusive circumstances, is that those contracts remain enforceable. They remain enforceable against a victim unless a court intervenes. So what I was interested in was when and how will courts intervene when they are looking at contracts that victims are signing. Now, Hayley, thank you. I'm so indebted to you for talking us through what coercive control is. The reason I have included this slide is to highlight the 9 behaviours that are up there on the slide. And I just wanted to flag that when I was selecting cases for my study, what I was looking for were any cases determined in Australian courts that involved a disputed contract where at least one of these behaviours was mentioned. That's how I collected my sample. So before I get into that study, and I keep alluding to the study, let me tell you what my study was about. It is about those contracts that women sign in abusive circumstances, and the fact that those contracts will remain on foot and valid unless a court intervenes. Now, when a court is looking at a contract like that, it will only set aside that contract if it feels that one of these established principles applies. Now, these established principles on the slide there, undue influence, unconscionable conduct, duress, and the Garcia doctrine, are collectively known as vitiating doctrines. So I will talk through what each of those are. I will leave the Garcia doctrine for the purposes of time and relevance, but I will talk through each of those doctrines, briefly explain what they are and how they may apply to a victim of domestic violence. Because my thesis was really interested in understanding how effective these doctrines could be for domestic violence victims, I was interested in their conceptual scope and how conceptually resonant they were with the idea of coercive control. But I was also very interested in what happens in practice in courtrooms around Australia. So I will be moving at quite a clip, and sorry, there is that methodology, the doctrinal split with the empirical study, trying to put those two things together to get a better understanding of how this plays out in Australian courts. So the doctrinal analysis was really me looking at each of these doctrines one at a time, considering what those doctrines cover, what the scope of those doctrines are, and whether those map onto the experience of domestic violence victims. And the reason I was interested in this question, and the reason why it was an important gap in the literature, is because the doctrines that I'm talking about were developed in English courts in the 1500s and 1600s, long before we had women recognised as legal persons, let alone any vocabulary to talk about domestic violence. So the one I'm going to start with is a doctrine called undue influence. Undue influence arises when there is a relationship of influence between two people that results in the weaker party's judgmental capacity being substantially impaired. So that is, if your relationship with someone means that you are influenced by them to the extent that your own judgment is substantially impaired, you may get relief from a contract on the basis of undue influence. Now, undue influence can be established in one of two ways. Firstly, you can have actual undue influence, and that is where you're able to bring direct evidence that at the time you entered the contract, you were being influenced by another person. The second way that you can establish undue influence is through a presumption of undue influence, and that is usually where you can bring evidence about your relationship as a whole that will allow a court to say, because of the way the dynamics of your relationship work, we can presume that when you signed this contract, you were being influenced by that person. So thinking about how this works for a victim of domestic violence, I've argued in my doctoral research that this doctrine is well suited to work for someone who's a victim of domestic violence. Thinking back to the slide on coercive control, it's clear that coercive control is about victimising a partner so that you can control them. So it is likely that a victim of domestic violence will be influenced to such a degree that their judgmental capacity is substantially impaired. Further, I argue that it's more appropriate for courts to use the presumed version of this doctrine because coercive control perpetrated over a long period of time and comprised of small acts is likely to have this compounding effect that is diffuse over the course of the relationship. And while it is possible that an abuser has issued direct threats about the transaction, it's even more likely that a victim's sense of helplessness has been built over time. So the next doctrine that I want to talk about is unconscionable conduct. This doctrine is triggered when the weaker party is said to have a special disadvantage and the stronger party has knowingly exploited that disadvantage. So the case law, when you go back through the hundreds of years as this doctrine has existed, reveals that when courts are trying to determine a special disadvantage, they might focus on the personal characteristics of someone. So for example, that they have a poor understanding of English, that they are old or frail, things like that. Those characteristics are said to make a person more vulnerable to the world at large when they are entering into contracts. A second type of special disadvantage that a person can have is a relational disadvantage. That is, in relation to a specific person, you might be at a disadvantage. And courts have focused on infatuation and gilded lovers and all things in that context. However, that analysis of relationships and being able to cast special disadvantage in the context of specific relationships is very useful for victims of domestic violence, and actually has a lot of resonance with how we understand the relationship between a perpetrator and a victim of coercive control. I argue that both undue influence and unconscionable conduct should be doctrines that are conceptually available for victims of domestic violence. Now, the last doctrine I want to look at is duress. And duress, for the non-lawyers in the room, is exactly what it sounds like on the tin. So duress is triggered when a person is subjected to illegitimate pressure, and that pressure has caused them to enter the contract. So a significant point to note about the status of duress in Australia is how courts understand or define what constitutes illegitimate pressure. At the moment, the law is unsettled in Australia, and the question that is unsettled is whether that illegitimate pressure has to be something unlawful or whether it can also comprise of lawful behaviours. This is a really interesting moment in time to consider that from the perspective of domestic violence, because of course there are forms of abuse that are criminalised and unlawful, but there are also, as we've seen, a vast array of behaviours that comprise a campaign of coercive control that are not criminalised. It will be interesting to see what effect a criminalisation of coercive control in various jurisdictions would have on a duress analysis. But at present, victims of coercive control can't point to behaviours like gaslighting and so on to establish illegitimate pressure for this purpose. A second problem with duress is that it requires a link between the pressure and the entering into a contract. And that has tended to rely on a fairly direct one-to-one relationship between pressure and a transaction. And the problem with coercive control is that it tends to be characterised by long-term victimisation. It's very difficult to point to specific conduct and make that link with a contract that you're seeking to set aside. So overall, my findings were that duress is not particularly well suited to address contracts that are entered into in the context of long-term abuse. So, the last thing I want to say is about claims brought against creditors. This is particularly interesting for women who might have substantial assets that are at risk because of coercive control and contracts such as mortgages or guarantees that they've entered into. So all that I've said about contracts being set aside tend to be in the context where person A is contracting with person B. So when the contract is between the victim and a perpetrator, and you can say that the perpetrator has unduly influenced the victim, or the perpetrator has taken advantage and special disadvantage of the victim, it is easy to set aside the contract on that basis. It is more complex when you are thinking about contracts that involve creditors, such as loans, mortgages, guarantees. And that is because the person trying to enforce the contract is not the perpetrator of the violence. It is a bank, usually. And the court's position in those situations is really trying to seek the justice between the parties. So if it's looking at two innocent parties, the question of when it will deprive the bank of the benefit of a contract becomes complicated. Now, in general, the law resolves this problem by saying, well, first you need to establish that the domestic violence is occurring, which triggers one of these doctrines, but then what will usually fix the conscience of the bank is being able to demonstrate that the bank had some awareness of that vitiating circumstance. In other words, what courts are looking for is evidence that the bank knew about the domestic violence and proceeded to enter into this contract nevertheless. This concept of notice is a real problem for domestic violence victims, and as I found in my study, it is impossible almost to bring a successful claim against a creditor for that reason. So even if a woman is able to establish that domestic violence has been occurring and the court accepts that evidence, they may nevertheless be consigned to still have that contract enforced against them. I predicted that that would be the result of my empirical study, and sure enough, we will find as we explore the empirical results that that is the case. So in my empirical study, I wanted to give you the raw numbers first. Now, I wanted to do this for two reasons. One is that you'll notice that the sample size of cases is tiny. This is not a sample of cases, this is the entire population of cases. I was really struck by the paucity of numbers, and it's something that I would really like to explore because it is very striking to me about what we know about the prevalence of domestic violence and financial abuse, that this number is so low. The table there, the reason why those numbers add up to more than 25 is because it's very common for women to argue more than one doctrine applies. Okay, so you can see there that you've got duress, a bit of a mixed bag, and you've got slightly more promising results when you start to look at doctrines like unconscionable conduct. These numbers alone don't tell you very much, and so what I did with the judgments that I had was I coded them. I coded them for themes that I was looking for to try and understand what actually was going on in the reasoning of these judgments that led to these outcomes. So coding, if you're not familiar with that qualitative research method, involves identifying themes with labels called codes, and then taking a text, in this case judgments, and marking that text with a code each time that theme arose in the text. So what I wanted to do was talk about the trends that I found. What gets in the way of successfully arguing any of these doctrines apply? And I found some interesting things. I found that credibility was an issue. The simple threshold fact of whether courts believe the evidence that women are giving. The second thing that I found interesting, which I found really resonant in Haley's discussion about condoning and minimising of coercive controlling behaviours. You can see that in judgments as well. And the last two things that I will briefly touch on are when courts were finding in favour of victims of domestic violence and setting aside those contracts, they were making some really interesting choices about how to express that reasoning. So the first thing I want to talk about is I want to talk about credibility. The tendency of courts to make adverse credibility findings about women's evidence was really striking. So in the cases that I looked at, 14 specifically talked about the credibility of women's evidence, and 7 of those made adverse findings about women's evidence. Now that's a small sample set, and because I didn't have access to the transcripts or anything that was going on in the courtroom, it's impossible for me to really say whether those comments were justified or not. But when I looked at the broader literature about how women's evidence is treated in courts, I found a great deal of writing on women's evidence in sexual assault cases and the dominant misconception that women readily fabricate stories about sexual violence. In the area of domestic violence, some scholars have written in this area suggesting that judges are often affected by incorrect stereotypes of how domestic violence will behave in the witness box and how they will describe their experiences of violence. So what I've got on each of these slides are a couple of the most egregious quotes that I found in my set of cases in my study. Okay, so we have this threshold credibility problem. If women's evidence is believed, we do also see other problems emerge when judges start to discuss that evidence. So the actual substance of what women are saying is believed, but it is being mischaracterised and minimised when judges are talking about it. So in the case Chaffin and Chaffin, the victim described the husband controlling who she was allowed to see, forcing her to give up her job and being volatile. And the court accepted all of that evidence, but as you can see, they described the abuser's behaviour as something that may often arise in interpersonal relationships where parties are planning a life together. In Imbardelli and Imbardelli, the court simply concluded that although domestic violence had occurred, it had not triggered undue influence, without any explanation of how it arrived at this finding. So this problem was actually evident across all of the doctrines, and my thesis actually explores some of the reasons why that might be the case. So the last 2 things I wanted to talk about really quickly were what courts are doing when they are actually triggering these doctrines and setting aside the contract in question. And the first thing I wanted to do was talk about what they do with undue influence. So if we manage to get past credibility and we manage to get past the trivialisation of domestic violence, what I found for the successful cases under undue influence is that courts always articulated this as actual undue influence. So if we think all the way back to my slide on undue influence, there are 2 ways that you can establish undue influence, actual and presumed. In actual undue influence, what you're saying is that at the time of the contract, I was, as a matter of evidence, being influenced at that time. And the problem with doing that is that even where courts had accepted all of the evidence of the entire relationship of abuse, they were still choosing to characterise their findings as being based on actual undue influence. And missing the opportunity to expand presumed undue influence to cover sort of situations where a woman might not be able to bring specific evidence about what was happening at the time they signed the contract, and not allowing women to rely on their account of their whole relationship. The last thing I want to talk about is approaches to unconscionable conduct. So this is the doctrine where a person has a special disadvantage that is being exploited. So you'll remember perhaps from my table that I had up for half a second that of the 15 unconscionable conduct cases, 10 of them were successful. Now what's interesting about that set of 10 successful cases is that 5 of them, so half of them, although they found in favour of the victim and accepted the evidence around domestic violence, characterised the special disadvantage as something other than domestic violence. So for those women, they were citing factors like mental illness or financial insecurity, which were ironically intrinsically linked to the domestic violence that they were experiencing. But they chose to eschew the language of domestic violence in their reasoning. Again, this I see as concerning because what it does is it indicates that courts are choosing the path that doesn't expand and make more robust those opportunities to develop the law for domestic violence victims. So, what did I want to do with all of these findings? I mean, this is what I found about what's going on in the courts when women are trying to get contracts set aside. One of the reasons I was so excited about working group was I really believe that my research on its own is not doing very much good. Actually, what is really, really required and important is for advocates and judges and courts to be aware of these phenomena that are going on. Not only the conceptual availability of doctrines, but when an advocate is sitting down and taking instructions from a domestic violence victim, they may need to know what they're up against in terms of how courts might treat that evidence and make some really strategic choices about how to try and build that body of jurisprudence. Because even if we have criminalised coercive control, the problem of what happens outside of criminal law and in the sphere of private law in contract is actually a separate set of legal principles that we need to co-evolve with our discussion about criminalising coercive control. So I have been very privileged to be able to share this research under the umbrella of the working group with Legal Aid ACT, with the ACT Human Rights Commission, and also, although we've had to reschedule this a number of times, it will happen in January with Women's Legal Centre. So thank you so much, Carolyn, for the opportunity to connect and engage with stakeholders.
Thank you.